The CPI report, Child Protection in Iowa, brought to you by Vocal, Victims of Child Abuse Laws. You can watch our program on Mediacom Channel 15 here in Greater Des Moines. It comes on Sunday afternoon at 1 o'clock. Again, it's repeated Wednesday evening at 9:30. You can also watch the program on Cox Channel 23 in Council Bluffs. It comes on out there every other Thursday. The time is 4:30 p.m. You can email us at vocaliowa@mchsi.com. My phone number is 515-276-3956. And John's number here in Des Moines is 515-282-2672. My name is Don Burgmaier, and with me at the controls is my co-host,
John Harvey, and welcome to the CPI report. CPI stands for Child Protection Issues, or Child Protection in Iowa. And there's a couple of things that we do as a mission for Vocal, Victims of Child Abuse Laws. Number one, attempt to influence public policy regarding child protection issues. And secondly, we intend to assist people who are having difficulties with the Department of Human Services. We are not attorneys. We don't hold ourselves out to do work of that sort. We don't appear on your behalf before the judge. We don't act in such a way as attorneys do. We're not skilled as attorneys. However, much of the skills that you need to resist the efforts of the Department of Human Services do not require an attorney. All you need is somebody who's been there, gone ahead of you, and learned some of the skills that are necessary to do a good and effective job putting your family back together again after the department or the juvenile court has torn it apart. And we'll do the best we can with the time that we have available to us. It is a time-consuming job. It is rather an interesting job to accomplish, particularly when people will listen carefully and will follow the law and will cooperate in such a fashion as to take advantage of what we've attempted to teach them. We had recently an individual who followed very closely what we told this individual, and she seemed to have a delightful time in going through a process which otherwise would have been very difficult. So we applaud her for doing things of that sort. Makes it a whole lot easier for us. And one thing that disturbs both Don and myself is when people will tell us their story, but they don't show up with the actual paperwork. And you can explain to us all you want about the rulings and about who said this and who said that and what the report says and so forth. But it isn't until you show up with the paperwork that we have any kind of an idea of what is going on. So when you do contact us, let us, give us a hint as to what it is that you're talking about, and we'll try to. We're not going to interpret the law for you because that's what lawyers are supposed to do.
How do they give us the hint again, John? It's through the paperwork itself.
Okay.
Parents, when you look at the action and you experience it in court, that's not enough to explain what the judge is thinking. When his thinking is put down on the documents that you receive from the court.
That's right. So and people will come to us and say, well, the DHS found me guilty. Well, see, the DHS can never find anybody guilty because they don't operate in that kind of a venue. They can make a founded report that certainly doesn't sound good for you, but they are not the ones who find you guilty. Guilty um, is a comment that you'll get in the you'll find that in the in a criminal venue. And we'll talk about these different venues if we have time on today's program.
But it's the DHS that's responsible for your loss in the courts. If the DHS wouldn't have intervened in the first place, you wouldn't be watching this program probably.
That's right. Well, so we'll try to straighten out some of those things. It is said that no one is safe when the General Assembly meets. And the General Assembly is in session right now. So no one is really safe because you have no idea about what paperwork is being done, what actions are being taken. We're going to look at some of the bills right now. We have passed what is called on the calendar the first funnel, the first major funnel for bills. That means that something has to have been done to them in one chamber or the other. When we say chambers, that means the House or the Senate. So something must have happened to the bill to keep it alive in this last half of the biennium. Well, and there's a few bills that are still hanging loose. Don and I will go through those. I'll read one bill, and maybe he can read the next bill, and so forth. We won't actually read the whole bills. Those would be torturous. And it's difficult. I can understand why an assembly person would find it difficult to do the job at the State House because some of these bills require a lot of thought and a lot of background, and you have to talk to somebody who actually wrote the bill or knows something about it. And that's why lobbyists are important. They love to have lobbyists because lobbyists will tell them more than they know, and in order to get a bill passed or to get a bill defeated in some cases. There's some of these bills. I put in some bills a few years ago. I said I shouldn't say I put them in because I had to pass them to a senator and to a representative, and they put them in the hopper. It cost at that time about $800 to process every bill. And I think one year Don and I put in 10 bills. Well, that's $8,000 it costs the state just to process those bills. Well, for the average assemblyman, reading those bills means absolutely nothing because they make references to other sections of the code, and it says substitute this and substitute that and so forth. So it makes it very difficult to know what is going on. But these lobbyists are only too happy to explain to the members of the General Assembly what these bills are all about. So you'll find lots and lots of lobbyists. In one case, one gentleman said that there were some 32 or 33 lobbyists just for the Department of Human Services. Well, the reason for that is the Department of Human Services spends much money. And that much money comes from government, from federal government, and from state resources. And these people that are represented by these lobbyists would like to have a piece of the action. They'd like to have a part of the money that is spent by the Department of Human Services as they go around tenderly caring for each of their clients. Well, in this particular case, where I told you I was passed in some bills that had to do with physical abuse and so forth. Believe me, the Iowa Medical Society was only too happy to tell how those bills should be defeated. And people have come later on to try to enact bills like that, and the uh, Iowa Medical Society would come right in again. They don't want any changes to, say, physical punishment or physical abuse. They want to leave it just like it is, so that anyone that says physical abuse, it doesn't make any difference whether it's physical abuse or not. If the department calls it physical abuse, the law is written in such a way that they are given preeminent attention in the courts to whatever the social worker thinks is physical abuse. And I don't agree with stuff like that. And I believe that part of our problem is in the courts, and that's why we've invited for a number of months Terrance Walker to step in here and tell us a little bit about what's happening in the courts, and we'll talk to him in just a wee bit here. Story number one. More money is okay to track offenders. Thomas Beaumont of the Register staff says the Iowa House agreed to spend $1.3 million more to monitor sex offenders this year, in part by setting up a real-time electronic monitoring system capable of handling 500 people. Well, see, they said on the registry there's like 6,000 people. Apparently, they've tried to pare that down to people who deserve to wear the ankle bracelets or whatever it is they're using to track them. The $2 million appropriations for sex offenders monitoring is part of the $575 million justice system budget. Includes money for to hire 8 full-time employees to administer a global positioning system. Isn't that great? We're going to use high tech to follow these people around. Even though they paid their dues to the full to the criminal justice system, we're going to use the high-tech system in this $575 million justice system to follow them around. The additional money for tracking sex offenders follows promises by lawmakers to step up supervision in light of the rape and murder of 10-year-old Jetsetta Gage of Cedar Rapids. Roger Bentley, a 38-year-old convicted sex offender, was found guilty in January of first-degree kidnapping and murder in connection with Gage's death. House File 2558 passed the Republican-controlled chamber 54 to 45. That's a pretty much a divided vote, isn't it? They certainly didn't get an overwhelming majority like they usually do on these votes on something this sensitive. I don't know why, and maybe we can take a look at that in just a moment, the kind of figures that they're talking about here. We're doing a good job of funding the priorities of this state, said Representative Lance Horbach, a Tama Republican. A Tama Republican. What sounds like we have some crosstalk here. We'll see if we can get that. Oh, I know what it is. It's my computer just decided to start talking.
Sounds like we're with the General Assembly as we speak.
Yeah, I think that's the House. Just shut off the computer, Don. Or there's a minus sign there that you can shut the volume down on it.
Okay. Don't you wish you could do that in real life sometimes?
Just shut down the General Assembly altogether.
Shut down the volume. They talk too much sometimes.
Can you see the plus and minus there on the keyboard? Just hit start and shut it off. Okay. Well, I've listened to some extent to the tried to listen to the General Assembly from time to time, and they're seldom in assembly. They're mostly in committee, which is probably a good idea because of the volume of work that they have to do. And I think they can consider these bills separate and apart from other things. Okay, uh, to go back to where the General Assembly interrupted me here, um, we're doing a good job of funding priorities of the states that Representative Lance Horbach, a team of Republican. The overall appropriations, including spending for the Iowa State Patrol and the Department of Corrections, includes 12.7 million increase compared with the spending this fiscal year, which ends in June. It adds spending for 26 supervisors of sex offenders. Boy, they're making a big to-do about this sex offenders, aren't they? In addition to 8 who would run the global positioning system and 500 electronic tracking bracelets. However, some Democrats said that the bill failed to address extra demands on local police. That's true. A lot of what the state legislature is accomplishing right now has to do with um, expanding all of these rules and tracking and so forth, and they are unfunded mandates for local law enforcement. It means that local law enforcement cannot do its job as well because it has to do all of these other mandates for which the state has no funding. That's called an unfunded mandate. Well, so it has these 26 supervisors for the sex offenders and 500 electronic bracelets to hang on these sex offenders. However, some Democrats said the bill failed to address other demands, the unfunded demands for local police. Representative Nathan Reichart said that local police departments are burdened with more supervision without additional money. And Reichart, a Muscatine Democrat, proposed an amendment to provide $2 million statewide to local police. Simply put, this amendment will give resources to law enforcement agencies so that they can have boots on the ground, said Reichart, whose amendment failed narrowly. So, did you have a comment there?
You're talking about where they passed a bill. It's going to cost $1.3 million, and this was based on Roger Bentley, who was found guilty. Wasn't he found guilty? And will he be serving a lifetime, John, in prison?
That's correct.
And so, therefore, this 1.3 million won't be applied to him, or he won't have a bracelet. And yet, they push through this law based on somebody that's been found guilty and will never see the outside of the bars, supposedly.
I hadn't even thought of that.
And so there's a lot of people that have served their time, as you're talking about, and it should be free, and yet, thanks to Bentley and the legislature pushing a bill through based on Bentley, then they're going to, even though we're not supporting the rapists, but if they've been, if the jury system or the judges have said they are only going to serve a certain amount of time, then we're against the fact that they're going to have to carry these bracelets when they get out or wear them.
Well, they can come up with all kinds of appropriations and all kinds of silly high-tech gears and so forth, but it only takes one person, you see, to get out of whack here and go and kill a kid. If it isn't a foolproof system, it's just going to cost us money. And once the interest dies down, and we're still going to have to pay these 8 people who are doing nothing but monitoring 500 ankle bracelets. That's 500 if they're all in service at the same time. So I'm not sure that that it's and then also we're going to have complications. What if 13 of those go off at the same time? You know, They have to somehow contact local law enforcement to take care of that in some little town 45 miles away from the closest police station. How in the world are they going to accomplish all this? Um, do it within a decent budget figure. You had a comment there, Don.
Yes. John, do you remember the name of the girl in northern Iowa that was killed in the home of her mother and the boyfriend? And uh, Jesse Rasmussen said that the social worker did no wrong, and they passed legislation. Didn't they? There was a lot of interest along that line, wasn't there, John?
They were going to get to the bottom of it. Remember that?
And Jesse kept saying that the DHS did everything right, and then 6 months later, Jesse admitted the truth, didn't she?
That's correct.
That's the way the legal system seems to work in the DHS. John?
Well, I think that we need to be watching these people that we elect to the General Assembly. Just spending the money and coming up with these wild ideas may look good on paper, but it isn't until you actually get on the ball and get something accomplished here. I don't think that running after the 500 abusers. Now, Iowa has also had some other brilliant ideas that we borrowed from the state of Washington and the state of Kansas, and that is civil commitment. That and also, don't we have a correctional system? If the correctional system hasn't treated these individuals while they were imprisoned, and if the penalties weren't stiff enough to discourage repeat offenses, I think we have a problem there. But then we have a civil commitment problem, civil commitment situation where it only costs $100,000 a person, but they can put, the last figure I saw was 31 people are in the civil commitment program. We've got so many different ideas for looking at these problems, trying to curb these problems, and it's just one thing after another that we're getting into. DHS cites good news, bad news in abuse reports, says Darwin Danielson. The director of the Department of Human Services says there is encouraging news in the latest report on child abuse cases in the state. Kevin Kincannon says that there's also some negatives. He says that the downside, they saw a record number of founded child abuse cases, as that number went up 2% last year. The report says that 13,544 abuse cases were confirmed in 2005, and Kincannon says one big positive is the report shows a continuing decline in sexual abuse cases, which he says allows a 10-year trend. He says there's also a downward trend of children who were abused again after the first abuse is reported. The report says nearly 91% of the children who had been abused or neglected went 6 months without re-abuse, a downward trend after the report abuse rate has held at 87% for the past several years. Kincannon says that fighting sexual abuse continues to be a worry. He says that it remains a challenge across the country, as there are horrific cases in Iowa and other states. Kincannon says that it's deeply troubling, and he says that they're always looking at ways to prevent it. He says that poverty is a big factor, and Kincannon says that the increase in single-parent families is also a factor in abuse cases, and I agree with him on that. I think that the single-parent families, while there are some super parents that can take care of children and can work a full-time job and can watch over and supervise their children at all times and so forth, it is a task that is beyond most individuals. And single-parent families, I think Kincannon is correct, are probably the places where child abuse could be prevalent. He says that the good news is that the state of Iowa has seen its teen pregnancy rate reduced. But that reduction in teen pregnancy, in my view, is being offset by an increasing number of children being born into single-parent households to people in their 20s and 30s. Kincannon says kids being born into single-parent household is much less stable circumstances than living in a single-parent household after a dissolution of marriage. Well, God didn't intend to structure the family the way we have structured families with single parents, whether they are parents that are divorced or whether they are parents that are raising children without both spouses being present. Kincannon says another positive for kids relates to the new state meth law. By the way, that has been effective, and it has drawn some national attention here in Iowa. And I say, praise the Lord that we're able to get at least a foot in the door on this meth issue. It doesn't eliminate the meth problem, but it eliminates the problem of meth being manufactured in Iowa. Iowa doesn't need that industry in its midst. Kincannon says there's been a significant reduction in the number of children exposed to meth making in their home. He says that due to the state's new meth law, that's why that happened. But Kincannon says meth still poses a problem to Iowa children. He says they will still see many, many children coming to our attention, coming into care because they're in families using meth. Kincannon says that the kids are at risk of being exposed to dangerous meth-making chemicals, but he says many don't get the proper attention from their parents because those parents are meth users. A complete summary of this DHS report can be found on Kincannon's DHS computer, www.dhs.state.ia.us, and I'll repeat that, www.dhs.state.ia.us. Okay, Don, did you have a comment there?
I wanted to comment on the first paragraph you were reading about Kevin Cannon talking about founded abuse reports. I'm sure you agree, John, that there's a lot more probably, founded reports than there should be. DHS gets aggressive on that. But I also want to point out that there are appeal rights for parents that get a founded abuse report. If that report shouldn't be on the DHS registry, they have the right to request expungement of that report. Now I'll take it one step further. Let's say that there's a several parents anyway. I don't know what the percentage would be, but we know that there are reports that do get expunged, totally deleted, because DHS did wrong. But DHS will never back up their number. They, not just back up, but they're saying here, the report says 13,544 abuse cases were confirmed. Well, on their paperwork, sure, that's correct. But in reality, no, there weren't that many cases that DHS should have founded in the first place. John?
Okay, you're absolutely right. And the largest number of cases, obviously, are in the area of child abuse, neglect, and lack of supervision. The reason why is there's no definitions. The definitions are so broad and so wide that um, uh, you cannot nail it down. So anything that the social worker doesn't like about your family, she or he can found a report on it. And if you look at the way the law is structured, uh, they call it deference is given to the agency who's supposed to be the expert on making these determinations. We found in one case that we looked at that they love to have expert witnesses testify. Expert witness who never even examined the child can tell that the child was beaten with a belt or beaten with some other instrument, and certainly wasn't harmed because of a fall from a bicycle. Well, now, expert witnesses who do this without examination of the patient themselves, that's what doctors are supposed to do, is examine the patient. But this doctor decides, because he works for DHS and gets paid by DHS for these expert testimony, you have to refer to them as a professional prostitute because they're getting paid for services that they render, which are not appropriate services. And I think this is unfortunately the way that we're doing business now. I don't think it's appropriate. Okay, we're going to take a break from the DHS stories here, and we're going to turn to a gentleman that we have come to admire for his knowledge and background and his insistence that the courts operate according to the rule of law. Now, why would he come up with an idea like that? Um, he's done a lot of reading and background research on what the courts are doing and how that deviates greatly from the rule of law. And he talks to individuals who are making some real headway in these areas. Let's now listen to the report from Terrance Walker.
Thanks a lot, John and Don. Excellent commentary, by the way, on the DHS, as usual. And kudos to you for doing your civic duty here with respect to the reporting of the malfeasance of the DHS and the shady actions of some of the legislators. For one, I'm Terrance Walker, the judge of the judges, and there's nobody else that does it, so I have taken upon my civic duty. A lot of people that see me in the street, they say, well, are you getting paid for that? No, I am doing this. I'm doing this as part of my civic duty, and you know.
You'll get paid twice this
go.
week what you were paid last week.
Exactly.
How's that?
Yeah, that's one way of putting it. It's more rewarding.
But it's appreciated when somebody comes up to us and says, thank you for what you're doing.
Exactly. And, you know, something that needs to be done. So, yes, I'm the judge of the judges. Maybe self-appointed. Maybe God put me here, but, you know, by the same token, it's something that needs to be done here. Because nobody out there is pointing out what our public officials in the judiciary are doing wrong. The media, they kind of turn their head at the whole thing because it's not junk food news, which something that they could just throw on the news and flash on the screen, and everybody eyeballs are going to be glued to it. It's kind of boring talking about the judiciary sometimes, but because they affect our life, liberty, and property, any decision emanating from the courts that can ultimately result in a determination along these lines, along a policy line affecting your life, liberty, or property. I think that it's very important that we stay in focus, stay in tune to what's going on there. One interesting case from the Iowa Court of Appeals that I thought was interesting, I thought we could share with the audience out there, from March 3rd, 2006, a guy by the name of Larry Joe Keaton. It was the state of Iowa versus Larry Joe Keaton. And this individual here, oh, we've got some visuals there. Uh, this individual here, very, very interesting case, very, very questionable case. Because, as, uh, as our founders had indicated, they guarantee us the life, liberty, and the pursuit of happiness. Well, they did not say that judges should take liberty with the facts or the law. Now, the legislator has defined robbery. This is a robbery case on appeal, by the way. Uh, I do not condone anyone to do anything that similarly suits these facts. But anyway, Section 711.1 defines robbery as a person commits robbery when having intent to commit a theft. The person does any of the following acts to assist or further the commission of the intended theft, or the person's escape from the scene thereof with or without the stolen property. And one of them is commits an assault upon another, or threatens another with, or purposely puts another in fear of immediate serious injury. Now, what's in question here is whether this gentleman, after going to a convenience store in Marshalltown, intended to commit an assault upon another, or intended to threaten another with, or purposely put another in fear of immediate serious injury. Well, these are the facts set forth. Larry Keaton, on March 28, 2004, entered a convenience store in Marshalltown and purchased a pack of cigarettes. When the store clerk opened the cash register drawer to make change, Keaton reached over the counter and grabbed the $20 bills from the register. He stated, "I'll take that." Keaton then attempted, again, I do not condone any of these actions by this gentleman. Just wanted to point out some interesting facts about the way this case was handled and decided. Keaton then attempted to exit the store, but the clerk rushed to the door and blocked his path by standing in front of the double doors. She also tried to grab the cash from Keaton's hand as he approached, but he would not release the money from his hand. Their hands touched when he attempted to retrieve the money. Keaton then briefly backed away from the door and extended his arm. The clerk realized she could not keep him in the store until the police arrived and stepped aside to allow Keaton to leave the store. As he exited the door, she snatched the hat from his head in anger. The incident was recorded by surveillance video. Now, again, an assault involves a theft, and a person in furtherance or escape from the theft commits an assault upon another or threatens another with or purposely puts another in fear of immediate serious injury. Well, I'm sorry, Iowa Supreme Court, who decided this case on March 3rd, 2006, either one of those elements are totally absent. Yet, they go on to state, we understand, oh, here it is. We began by considering the actions of the parties. And they go on to talk about his arm being extended as he's trying to leave the store. And they said he pulled his hand to his chest at the same time as the clerk moved off to the side of the door to permit him exit. They conclude that this is substantial evidence to define the element of assault. And this decision, who was done by Justice Cady, who wrote the opinion on this case, I would say, Judge Cady, you are the real Slim Shady, because you are very shady in arriving at your legal conclusion there. For one, I don't understand how someone leaving the store with their arm extended, unless they were looking like they were going to punch somebody, which they didn't say in this opinion. I understand how that would be classified as an assault. it seems to me that the judiciary here is taking not only liberty with the facts, but taking liberty with the law. And to me, pretty soon, they're basically going to have one kind of crime when it comes to a theft here, and they're not making this distinction. Anybody that commits an assault or commits a theft, they're going to hurry up and classify that as a robbery. And what does that do? That puts a tremendous burden on our justice system, puts a tremendous burden on our resources here, prison system. A lot of these crimes, robbery, burglary, some of these more, I would say, violently described laws have mandatory minimums, 85%. So what do? You take a guy who has committed a theft and you elevate that to something whereas they're going to be spending at least 8.5 years on the 10-year sentence, an 85% rule that they implemented here in the state of Iowa. And you've got a lot of tax dollars being shifted away needlessly from other resources such as education, health care, and things of that nature, and you shift it towards supporting things like this. Well, I'm sorry, Judge Katie, but like I said, your opinion is very shady, and you guys are obviously trying to enlarge the terms of this statute to encompass any and all acts of theft that apparently occur within the presence of someone. It doesn't make any sense. But on to the next subject here, because I think that not only are the judiciary enlarging statutes unnecessarily and being lazy when it comes to their interpretations, but they're being lazy when it comes to doing their actual work as a whole. One such incident here, this made the national headlines, probably wasn't on front page like it should. And we pay these individuals we call judges large sums of money. All the ones in the high courts that I know of in every state make six figures a year. So they're not by any means unrewarded public servants. They're very rewarded public servants, and we should hold them to higher standards. But in the case of the United States Supreme Court, we've got an individual named Justice Ruth Bader Ginsburg, who apparently, during a case in which they were discussing redistricting the state of Texas, I guess the subject matter was extremely technical. Near the end of the argument, they had an oral argument in which Ruth Bader Ginsburg, the Supreme Court Justice, put her head down on the bench and got her 40 winks. So there you have it. Six figure a year. Should be another picture of that on that second slide right here. Yeah, on that second.
Oh, yes, okay.
But I thought this was interesting because they don't allow cameras in the Supreme Court yet. Someone actually pinned a picture, and it was a very good picture.
You see, that's why they don't want cameras in there.
Yeah, that was
to tell the truth.
It would be very damning to the justices of the Supreme Court or any court if they were caught doing something like this. Now, this says Justice David Souter and Samuel Alito, who flanked the 72-year-old, looked at her but did not give her a nudge. At first, she appeared to be reading something in her lap, but after a while, it became clear. Ginsburg was napping on the bench. Snorer in the court. So not only do we have people that are lazy, but they're sleeping on the bench. A couple other cases here in the Iowa Court of Appeals. Now, this is further evidence And I'm making my case, by the way. So, this is what you got to do if you're going to be presenting something legal here. Uh, the next case, Anthony Barnes versus State of Iowa. Now, this individual here appealed his case. Apparently, they filed a brief in the Iowa Supreme Court, which was decided by the Iowa Court of Appeals, and it was post-conviction relief. And let's see what your tax dollars are paying for. Can we look at all the hard work and the of the justices here? We're paying 6 figures a year. Okay, this is Judges Hootink. And you know what I say about Hootink? If you get his opinion by Hootink, then you know it must stink. Anthony Barnes appeals from the district court's denial of his post-conviction relief, arguing his counsel was ineffective. After careful review of the record, well, they say that all the time, but where's the analysis? We don't see no analysis. Come on, you getting paid 6 figures a year, and this is all you can do is 2 sentences? I could have wrote that, and I could have put after careful review of the record. That doesn't take much work. That just says that you want to appear that you carefully reviewed the record. That doesn't mean that you adequately and carefully actually reviewed the record. Anybody could put that down. Did you have a comment on that, Don?
That reminds me of a court action I had going on, and I filed papers, and the judge responded, and he said, after reviewing the court record, and Mr. Burgmaier had not submitted his document, he made the ruling. I go down immediately to check the court file, and there my paper was right on top, the very top one, and he said it wasn't even there. That
So he
I
carefully
don't know
reviewed.
what to say.
He carefully reviewed the record.
Yes.
Or
He said he did, and it was Burgmaier's paper wasn't there, and there it was.
6
He didn't even
figures
have
a year,
to
folks.
look down below. It was right on top.
Well, here's another one, and Richard Everhart versus State of Iowa. And this is another one, Richard Everhart. I guess the Supreme Court doesn't feel like it, or the Iowa Court of Appeals doesn't feel like it owes any explanation sometimes for its actions or inactions. It's another case decided March 1st by the Iowa Court of Appeals. As you can see, all they had to do was have the clerk type in a different name and maybe change the concluding sentence or sentences, which are only a few. But there's one justice of a 8th Circuit appellate court that says that they've decided cases on the Court of Appeals in the 8th Circuit at the rate of 50 every 2 hours. So who's to say that they carefully reviewed the record? If this is what carefully review the record means, is that they give you 2 sentences and they give you 2 cases or a case every 5 minutes, I would say that might not be careful review, especially when you have a 30, 40-page legal brief with a lot of different citations. But we therefore affirm without opinion. Isn't that the epitome of arrogance and ineptitude? We therefore affirm without opinion. Well, I therefore affirm without opinion that you're not doing your job.
Notices per curiam, too.
Yeah.
We're going to cover it up.
Yep. Can we, do we get the affirmance? Can I get the affirmance on that? Do I have my concluding comment back by this panel of judges?
You bet.
We affirm without opinion.
Yeah.
Well,
I understand that if you go in as a pro se attorney representing yourself, that you should not argue ineffective counsel.
yeah. Well, it's the epitome of arrogance that's displayed within the legal establishment that, a pro se person doesn't have the wherewithal to represent themselves. A pro se person can't effectively uh, navigate the system and file the right motions on time. And then on top of that, to be a further insult to a pro se person, they say, well, you know, you, you can't claim an effective assistance of counsel. That's, and they shun any allegations by a pro se litigant that
Right.
their counsel is ineffective. I think I've only seen in one case where they've actually said that by a pro se litigant that their counsel is ineffective. There's one case. It's astounding. And I've looked at thousands of cases over the past dozen or so years. Um, but this leads me to my concluding remarks. I think that what needs to be taking place here is we need to be vigilant here when it comes to our life, liberty, and property, because, like I said, the courts are the final arbiters of these rights and the interpretation of these rights as it is construed and construed in context with the statutes that are coming out and the common law and other judicial opinions. So we need to be vigilant, because if we're not, we may all be subject to very aberrant practices and policies and interpretations of the law. And just one example that I pointed out earlier by one gentleman, like I said, who had, like I said, I don't recommend anyone do this, but he had went into a convenience store, snatched the money, and ran out the store, extending his arm supposedly. Now, it wasn't said that he had a fist, but that in any stretch of the imagination to me would not constitute an assault, which would also justify them concluding that it was a robbery. But this is what we happen in this day and age when you have a judiciary that's out of whack, that wants to
Out of
enlarge
control.
the statutes and enlarge the meaning of the ordinary words. But that's why we have the retention vote, and that's why my organization VJO, Vote Iowa Judges Out, has been urging the people here in the state of Iowa to vote out the legislature, or vote out the judiciary. And if they don't enact what's called the Judicial Accountability Law, which we're going to also point to on this flyer here, a website, you need to get onto this website and view the actual law and the petition which we're submitting to the legislators to enact. We didn't make this year, unfortunately, because the funnel dates passed for us to enact this legislation. But by next year, we will be ready, because this is something that we can also utilize on top of the retention election every other November, to actually hold the judiciary accountable by some sort of means that is workable. Because we have the appeals process that's proven to be unworkable. We've got the Judicial Qualifications Commission in this state and almost every other state, and that has been proven and shown to be unworkable. But this is a workable solution, because the Judicial Accountability Initiative, or law, would actually make the judges answer to a grand jury of citizens if they are basically held to have, or found to have been violative of the statutes or disregarded the law. Or there's 7 different factors. You have to get online and actually read it, but it's weblocation1.com/petition, and view it for yourself. If you want to, let us know your thoughts on it. And you can also look up the jail website. It's jailforjudges.com. That's the number 4. And jailforjudges.org, I'm sorry. And you'll actually see a more expansive background of the legislation. But that's my 2 cents for today. I'm going to pass this mic back to you and John and Don here.
We had a case similar to one you're talking about here in Des Moines, Iowa, where a gentleman, I don't know if you call him a gentleman because he went and swiped a piece of fishing gear from a Walmart store, and he was sent to prison for 15 years because of that. The reason why, it wasn't just a simple theft of a $14 fishing reel, but it was it had the added bonus of more time because he escaped detection, and he also threatened the guard. Well, what he did was he ran out. It was raining, and he ran out to escape detection, and he hid underneath a car. They couldn't find him, so the pursuer, security guard, found the evidence of him being attacked because he found a branch out there that was rotten. It was so rotten that it could not have inflicted any pain on anybody. But he showed that in court, this branch, and that was sufficient with it, along with his story, to show that he had been attacked, and that wound up with a 15-year sentence. I think we are wasting the time of the court. We're wasting, and this is not to put any accolades on somebody who would go in and steal something from a discount store, but it seems like to me that we're wasting a lot of time on these enhanced penalties that you spoke of earlier, Terrance.
And these enhanced interpretations.
Yeah, very, very much enhanced interpretations. Here's some numbers that you may be that may be of some interest, and I want to go over one other document here, if we can, Don, that shows something about the kind of venues that we get, because it's somewhat disturbing. There's a sheet that says venue at the top. It's somewhat disturbing because of all the different areas that we're looking into, and there's DHS, and there's criminal court. There should be right in here. Okay. Well, we're going to run out of time before we get to that. Why don't we put our number back up, Don? Because we're not going to get those located. Why don't we put up our vocal number once more? Okay, some telephone numbers that may be of help to you if you need assistance in preparing your resistance to the Department of Human Services. You have a perfect right to do that. Oh, Don did find the report here. The DHS is one venue, juvenile court, the district court, and the Supreme Court. And we'll talk about that another time. We'll see you